All right, this would be case D473360, the Ruiz case. Counsel prints the record.
Good afternoon, Your Honor. Nadine Cutter on behalf of Plaintiff Eric Ruiz, who's present. My bar number is 11548.
Good afternoon, Your Honor. Current Price, bar number 10237, present with defendant Rosa Maria Ruiz.
Okay. I will let you know what I've reviewed again. Give you the opportunity to see if there's anything to add. First of all, Mom filed a motion in pro se asking to modify child support. She also filed a motion around the same time to have jurisdiction changed. This court denied that request on May 31st. Dad filed an opposition on May 25th by Ms. Cutter's office. In that, he was asking for several things, including modification of custody. The court has also reviewed a reply filed by Ms. Price dated July 5th. Indicating what child support should be, and then there was some issue regarding unreimbursed braces. So, is that everything?
I believe that covers
Approximately? All right.
That is everything. I wish I could have filed a reply to their counter that was attached to their reply, but it was just filed on the 5th. I didn't have any time to do so prior to today's hearing. But I'm happy to address that verbally today.
Well, here's the thing. I'm even apprehensive. First of all, I am going to go ahead and modify child support because there's clearly been an increase. In fact, given his paycheck stubs, the amount that I get, make sure I'm not overstating it. I'm not. Including all of his taxable income, would be $84.56 a month. 29% of that would be $26.21 per month.
Your Honor, his income is $5,203.47 per month, based on an hourly wage of $30.02 an hour. And his overtime pay was
I double check my law clerk's work, break it down by the day, according to the paycheck stub that he attaches to his FDF. It includes all his taxable income. We only include income as considered by the IRS. Overtime, everything.
Yeah, we included overtime in our.
You're right. And so I'm telling you, what it comes down to is 84. The number is 84.56. So.
There's one huge conflict in our papers and counsel's papers, which I think is a mistake on Mom's part. Dominique, without any dispute, who is the 19-year-old, has lived with Dad for 2 years, for sure. So I think they made a mistake in their moving papers when they said, "Oh no, Dominique lives with Mom." I don't think
Dominique's emancipated and has. I have no jurisdiction or nothing to do with it.
I just wanted the court to be aware, because we were asking for, that to be taken into account by the court. Moreover, all 3 kids are living with Dad right now, and they are going back to Mom on August 5th. Is that correct?
Mm-hmm.
August 5th.
Well, living's
And Robert.
selective term, I guess. They're here for summer vacation, right?
Yes, correct.
Right.
Correct.
That's not. Man.
We wanted the court to be aware of that. And we are, would the court like to entertain oral argument on our...
I've read everything. Unless there's something very compelling that's happened since I've read all these pleadings, again, I will, because not only did I reread their stuff that they filed, or at least what the plaintiff filed before, here's really what it comes down to. I just get this impression your client's response for custody was in response to her request for child support, which ironically more than doubled. That being said, if your client has been so concerned or really concerned about these children, why he wouldn't have contacted Child Protective Services down in California. Thirdly, if in fact he wants to do something, I'm very reluctant. Let me just preface it with that. Very reluctant. But if he wants to front some sort of multi-$1,000 outsource assessment for a recommendation that he would meet an Ellis standard for a modification of custody, that's probably the best he'd be walking out of the court with today.
Preliminarily, and I appreciate the court's statement just now. He has $100 in his checking account and $5 in his savings account.
Okay? So he's probably not going to be able to afford a...
Secondarily,
Okay.
his motion specifically states valid concerns that mom has had 5 different addresses in the last 3 years, including the Ronald McDonald House, that mom has and is still in an abusive relationship, none of which is addressed in their reply in opposition. They just gloss over it and don't say anything about it. They claim it's resolved, but mom is still with her abuser.
Scudder, I'll reiterate, you're now taking this hook and arguing the same stuff I've already read. I've said I've read all that. I've read all that, including Ronald McDonald House, including the abusive relationship. They are just simply allegations, suspiciously in response to when she asked for child support to be increased. That's all. I'm just simply noting that. I'm, again, even affording him the opportunity to do an outsource assessment. If he can't afford it, he can't afford it. Some people have to beg, steal, borrow from family members to even afford to be able to do that. I'm not even positive that I would grant him that. I will wait to hear from his price if she's going to adamantly object to it and reasons why. But that would be the best that he would even get out of this. And as far as abusive relationships and not having stable, you can shake your head all you want, they do that stuff for CPS here in Nevada all the time. All the time. Is he called Child Protective Services?
I did not.
No, he has not.
Right. So.
One thing I didn't hear the court say is an acknowledgement that Dad is saying he saved up, which is obviously extremely hard for him, got a house that he wants the kids to live in. He's asking for a child interview of the 16-year-old Robert because he is over the age of 14. We thought it would be highly likely to be granted by Your Honor.
That does not meet an Ellis standard. That absolutely does not meet an Ellis standard just because a child grows a little bit older.
Well, we think the Ellis standard is met with the following. Dominique, the 19-year-old, has lived with them for 2 years.
Scudder, I'm not about here to sit here and debate things with you. I have read it. We now have a record of it. I have reviewed it. I don't find that there's adequate cause. If, in fact, your client wants to finance, maybe he could take a loan off of that, or a second, against that nice, great big house he bought, hoping that his kids would come live with him, and pay for an outsourced assessment that might make that recommendation that they come and live with him. If, in fact, he wants to do that, I'll consider doing that. Shy of that, there's not a basis for me to modify custody.
What about the 16-year-old's wishes?
That does not, in this court's mind, ever meet the Rooney standard. Just because a child grows older and would maybe like to live with the other parent is not a substantial change in circumstances affecting that child's welfare.
And the court's not concerned about moving.
It is a one sub-factor of the best interest prong in Ellis standard.
And the court's not concerned about mom moving 5
Your client
times.
was apparently not concerned enough to even pick up the phone and call anybody.
That's not true, Your Honor. I mean, calling CPS when there's a parent involved in the children's lives is just going to result in an enclosed as unsubstantiated
Would your
letter,
client like
which
the
90% of all CPS
Would your
cases.
client like the referral for an outsource evaluation, or would he not?
Would it be another one to somebody like Mr. Paglini, which Your Honor has referred out to in the past, who costs
I don't think it needs to be
$4,000?
I don't think it needs to be a PhD level.
I don't know that my client has the funds to do any of that, Your Honor.
Okay.
What he was hoping would be FMC to interview Robert. The court
I'm not going to interview Robert. Let me be very adamantly clear. Even if a 16-year-old child tells FMC over there, I want to come live with Dad in his nice, cool new house, it's not a means for me to change custody. It absolutely is not for me to meet.
In our motion, we primarily moved for primary. In the alternative, we moved for joint under AB 263, and perhaps, Your Honor, would be
AB
willing
263
to
did
send
not
them-
set aside Ellis.
Perhaps, Your Honor, would be willing to send these two to FMC to talk about a joint schedule, because Dad has a lot of concerns about the abuse
I'm not
and
Miss
about
Cutter.
moving residences.
Not Miss Cutter. I'm assuming she doesn't. Does she want to talk about joint?
No, Your Honor.
Yeah, I saw her about to fall over. So no. Anything else?
I'll wait for reply.
Okay. Well, I guess the issue is, would your client adamantly oppose if, in fact, he came up with the money and decided to pay for an outsourced assessment?
My initial reaction is to say yes, because why would it put the kids and the family through that?
Well, that's my gut feeling, but if he believes there's enough there, and let me say it barely kind of makes it. I don't know until someone investigates the relationships, and until someone investigates how much she's moving around, until someone investigates the places she's staying at. They don't meet the adequate cause for me and I don't know if there's really a standard for me to really send it out for an outsource. They really absolutely don't meet the standard right now based on the allegations for me to change custody. But it would take a little bit more from someone investigating.
Our recommendation would be he just comes to California and sees the kids there, cheer them on at the football games, come and meet their teachers, come and meet their friends. He's welcome to come up and visit with the kids as many times as he'd like. And at that point, see if the kids come over and see Mom's house and what the kids are up to and what they're doing. Robert just made the football team. He'd love to see his dad there.
Well, he'd rather just have the kids.
Pardon?
He'd rather just have the kids.
But that would be, I'd say, first thing. We have asked for attorney's fees and costs, Your Honor. The income disparity in this case is huge.
You ask what? I'm sorry?
For an award of attorney's fees and costs, $950 is $1,950 is what my client had to put forth to defend the action for custody, which was denied clearly at this juncture.
What I will have to do is, if in fact you are going to do that, I'm not going to make you file a new motion under NRCP 54. You did request it in your pleadings. It would just simply be a supplement with a detailed Miller-Wilfong analysis, which would include a detailed billing, and then I would take that in consideration. I would need that supplement within 10 calendar days, and then Ms. Cutter would then have 10 calendar days to file any response as to why she believes that amount would not be reasonable. I will note, Ms. Price, again, that you were successful, but it was a necessary hearing. I mean, it was a necessary, she had to come back, it was a mandatory review. I mean, that's really the main reason we came here. He did kind of come up with a... Up the ante. He came up with a now I want the kids type of thing, but she had to come to court to get child support increase, which I am going to make effective as of July.
The last issue, Your Honor, is it's my understanding that plaintiff stated that he would provide the child, Robert, with braces. My client provided $1,600, $1,700 of payment for those braces, and they were never put on the child. She's now making arrangements to have the child actually get the braces along with the other child in August.
Okay.
I would ask that that money be refunded to her so she could put that towards the orthodontic costs. And they don't actually have a 30-30 day rule for the division of unreimbursed expenses like that. So we asked if that could be implemented in the order from today as well, Your Honor.
I will go ahead and incorporate a 30-30 rule if they, for some reason, don't have one in their existing one. Was the allegation he took back the money? I thought she still had it.
No, my client gave him the $1,600. It was $1,690.
But now you're saying that he's going forward and getting it done.
No, my client's going forward and getting it done. He stated he would get Robert braces.
Let me stop at this period and indicate that I guess if you're going to get the court involved, which clearly you are, then I'm going to need a letter from the dentist and or orthodontist that indicates that these braces are medically necessary, because the statute only requires that I order half reimbursement of medically necessary, not cosmetic type of things.
This would be my client paid him for braces, which were never put on the child, so she's simply requesting the braces money back. So it's not a reimbursement issue as much as
I see what you're saying.
she prepaid for something that never actually occurred for Robert.
This is getting, and again, it's been a long morning. I'll start and admit with that, but we're getting into areas that people. I don't know.
I don't think he disputes it. This may be a simple issue. If he does, then
Did she give you the money?
She never gave me any
No,
money.
Mom has been on Medicare, and so he's saying the state of California is paying for the braces, but Dad adamantly denies having any $1,600 anything, and I'm
It's
sure
one-
he
it's
would
one of those
swear
things
that
that,
he
you know,
doesn't
these-
have that. So we don't know why Mom is trying to allege, that even happened if she's having the state of California handle those costs anyways. So
Yeah,
why
that
would Dad
seems
get
a-
it checked? That doesn't even make
I'll be
sense.
candid with you. That seems a little suspect. She may have to track it down, and I don't know that at this juncture. Again, it's not really child support related. I don't know if someone would give someone a lump sum in order to do that. So I don't know that I'd end up with jurisdiction over that, if that makes sense. Some people get the misconception because I end up doing their divorce, and they have these ongoing disputes like, I don't know what's going on with the co-signing of whatever, that I get to handle all their family problems for the rest of their lives. And that's simply absolutely not true.
you're telling us that now?
What?
You're telling us that now? Teasing.
I know some judges do, but... Ms. Cutter, you can add anything you want to the record, and the final question will still be if your client would like the referral to for the outsource. And it does not need to be a PhD level. I can't give you a price about how much it would cost. It's a custody val, even with an MFT or an LCSW, is still usually going to run $5,000 to $7,000 out.
He is shaking his head that he can't afford it, and he showed me a screen of his phone with his bank account.
Okay.
It had $100 in the checking and $5 in the saving. So he absolutely can't afford it. Moreover, for the record, we strongly object to Ms. Price's statements that Dad doesn't see the kids. It is so false and so beyond false. Dad goes every month to see the kids. Dad has the 3 kids right now. The one child that's 16 is trying out for football, and he hasn't had a game yet. So it's disingenuous to say, hey, you should be coming to the games. Dad is a participating father. Dad does see his kids. So it's not right to make the statements that Mom made before Your Honor, because it's not this case. And Your Honor, there was a deviation for transportation way back 3 years ago. Okay? Dad doesn't get to meet in Barstow or do some nice in-between thing. No. Dad hauls his car all the way from Las Vegas to California and then all the way back to whichever one of Mom's 5 addresses she happens to be at. And it's not fair to not award him some sort of downward deviation again just because she files a pro se motion. And she was the moving party that started this and opened Pandora's box, not Dad. Dad defended himself. So we object to any request for attorney's fees because Dad
You can
has a valid
you can list that
concern.
in your filed response. I'm not
We
going to
did.
take oral argument regarding the attorney's fees today. At the end of the day, she came to court. She legitimately and rightfully got her child support more than doubled.
Well, we think there should be offsets made for the
How
transportation.
much was he getting before? I don't.
$382, if I remember correctly. But I can check. Dad's been paying $1,250 for the last 3 years,
Mhm.
despite having the oldest live with him for the last 2.
That's his.
And Dad has been paying.
I can't do stuff
the tran-
retroactive, Ms. Cutter. You know that.
And then Dad has been paying for the transportation, all the way from Las Vegas to California and all the way back. It's a lot of work for Dad and a lot of cost. And with someone, that could barely cover a gas bill right now if he were to do it
You have a
today.
proposal regarding an
That's
offset just for
difficult.
travel, because he did have one prior to.
He didn't have, I'm sorry, you a proposal? What's a tank of gas
Well,
for a month? He doesn't visit except for long weekends. The kids are here during the summer breaks. So he's got the 2 holidays a year and summer.
That's not true. He doesn't have 2 holidays a year. He sees the kids every month. He sees the kids holidays, and he sees the kids the whole summer break. There's winter break, spring break, birthdays, Father's Day, Thanksgiving.
I'm going to get,
I was
all
splitting
there.
the travel, if that would make it easier. She'll
Sorry?
drive one way, and he could drive the other way?
no, your client is one who relocated to the state of California, correct?
Yes, sir.
So she's responsible for all travel costs. I think I was quite generous the first time, so even on a monthly basis, I will set it in the same amount, which was $632. $381 a month.
$300 and $81.
That should include. That's gonna sort of include a motel and food but
Well, he drives down, picks them up, and he brings them back. He doesn't stay there. It's only 4 hours.
that's what he was getting before. That's what he was getting
I would
before.
just ask the court if we could make it more realistically reflect the actual expense that he's incurring for the travel costs of seeing the kids when he sporadically does. The children shouldn't be losing out on their support because of a arbitrary travel expense, which doesn't authentically exist.
I think that was actually a stipulated amount from before.
Well, that was just the two of them not understanding the numbers.
I understand. I'm just simply incorporating it, giving the cost and everything else. So, see, now they're not happy.
So what is your honor's ruling as far as the child support?
Whatever
The
the
actual
amount is
number.
minus 361. What is it, Madam Clerk? The end result.
Oh.
Sorry.
I can't hear you, Madam Clerk.
I did not do the math. The original amount was 2621, correct?
2621 minus 381.
That would be 2240.
Again, we'll make that effective as of July of this year.
Your Honor, I'd like to verbally say that my client cannot afford that, and it would produce a severe financial hardship. He's been paying $1,250.
Maybe he can show you a picture of his nice new house that he just bought. Maybe that would impress you.
Your
I'm done for
Honor.
today. You can, if
We
you want to
have
add
the
anything
vote.
else to the record, you can add anything else to the record, Ms. Cutter. Yeah, 5 days to sign off and review, and if not, you can submit it directly to the court.
Could we split the child support payment in 2?
I have no problem with 1st and 15th. Well, yeah, if you want, that's actually better. Otherwise, it'd be the last of the
And Your
month.
Honor, can I ask real quick, what year-to-date figure did you guys come up with 8456? Because ours was $7,089, and now we're off by $1,400. So I just want to know, in case I have to do, some clarification motion or something, where you got it from.
Sure, Ms. Cutter. I will tell you specifically. That was based on his gross monthly income, where he reported $33,341 in 120 days, and then we divided that back out.
33,120.
$33,341 in 120 days.
And you divided that by.
We did the calculations from there. We're all not the greatest at math, but that's where it came from. And that was from his paycheck stub.
Are we done the hearing?
We're done.
May
We're
I
off.
leave?
We're off. So
Based on my calculation, that's off a little bit if I do a daily calculation, because there's 31 days in January, 31 days in March, 30 days in April, and the period
just cut or
ends-
file, whatever you need to do. We based it off 120. We based it off his.
With all due respect, my client.
We based it off his paycheck stub. We reduced it down to 120 days, and then we divided off the 120 days. That's how we came to that calculation.
Right.
Right. And then we also gave him a significant deviation for the travel expense,
Okay.
which I can reconsider that if you want.
I count 122 days. And I count.
Have a nice day, Miss Cutter.
300